Good afternoon, ladies and gentlemen. I'm Eileen O'Connor. I'm chairman of the Administrative Law and Regulatory Practice Group. Thank you for choosing the Ad Law Practice Group's panel this afternoon. There are a couple of other interesting things going on, but you might be planning to do what I am, and that is watch the others on video next week. I'll introduce today's moderator, who will introduce the topic and this afternoon's panelists. But first, let me mention just a bit about practice groups and executive committees. The Federalist Society has 15 practice groups, each of which focuses on a specific area of law. Each practice group has an executive committee whose membership consists of 24 or so lawyers engaged in government, academia, private practice, or the corporate world. We meet on the phone for about half an hour once a month to share information and ideas and plan events from which we think the membership will benefit, like teleforum conferences and this afternoon's panel. If you're not yet a member of a practice group and are interested in joining one, please see any member of the Federalist Society staff or go online. Now it is my pleasure to introduce the moderator of your panel this afternoon. First, on a personal note, I must mention that as a first-generation American, I found it particularly intriguing that our moderator today is a member of the 6th generation of his family to live in Idaho. His ancestors, in fact, were there long before it was even a state. More to the point for our purposes today, however, Ryan Douglas Nelson is the second of 8 United States Circuit Court judges nominated by President Trump and confirmed to the Ninth Circuit. He was confirmed in October 2018 to the seat vacated by the taking senior status of Randy Smith, also of Idaho, whom President George W. Bush had appointed in 2007. Judge Nelson maintains his chambers in Idaho Falls, Idaho. He is a graduate of Brigham Young University and with honors, its J. Reuben Clark Law School. During law school, Judge Nelson clerked for then Senate legal counsel Thomas B. Griffith, now of the D.C. Circuit, during the impeachment trial of President Clinton. Law degree in hand, he then clerked for Judge Karen Henderson on the D.C. Circuit and then moved on to the Iran-U.S. Claims Tribunal in The Hague. He was with Sidley and Austin for 9 years, served at the Department of Justice as a Deputy Assistant Attorney General in the Environmental and Natural Resources Division, and then at the Office of Management and Budget as Deputy General Counsel. Immediately before his appointment to the bench, Judge Nelson for 9 years was General Counsel for a billion-dollar consumer products company based in Idaho Falls, Idaho. He became a member of the Federalist Society in 1997, and appropriate for our topic this afternoon, served for 6 years as co-chairman of the General Counsel Committee of the American Bar Association's Administrative Law and Regulatory Practice section. Judge Nelson.
Thanks to everyone for coming out today, and I'd like to introduce briefly the panel we've gathered together to talk about non-delegation after the Gundy decision. We've first got, and I'll introduce them in the order that they're speaking. We've got the Honorable Ronald Kass, who is currently serving as the president of Kass and Associates. We have Professor Kristin Hickman, the distinguished McKnight University professor, Harlan Albert Rogers, professor in law, associate director at Corporate Institute at the University of Minnesota Law School, and I will note also a fellow D.C. Circuit clerk back in 1999, a few years ago. We have Professor David Schoenbrod, the trustee professor of law at NYU Law School, and then Professor Alan Morrison, the Lerner Family Associate Dean in Public Interest and Public Service Law and Professional Lecturer in Law at George Washington University Law School. And I understand this is not the end of his day. He's going to go teach some students tonight as well. So with that, we'll turn it over to Ron, if you want to go ahead, and we'll have everybody give some comments.
Thank you, Judge. Delighted to be here. And every program must begin by law with a true story. This story is, as you will recognize the truth, it is a priest, a minister, and a rabbi having a discussion about funerals. And they talk about how difficult it is to find the right thing to say at funerals. And at one point, the conversation turns to, what would you like to hear said at your funeral? The priest says, I would like to hear someone say, he was a good shepherd to his flock. The others nod. Minister says, I would like to hear he was a good shepherd to his flock and a good man to his family. The others nod again. The rabbi said, I would like to hear someone say, look, he's still moving. And of course, the topic today is the delegation doctrine still moving?
All right.
You knew there'd be a segue there. The constitutional design is really based on structure. And the chief structure is the separation of functions, the separation of powers among the three branches of government and between the federal government and the states. I'm going to ignore the states. Being a longtime ad law professor, I'm used to ignoring the states. And talk about the separation of powers within the federal government. If you look at the vesting clauses very clearly specify who gets what power. A lot of people look at them and say, okay, we see who gets what power, but that doesn't say anything about what you can give away. To which the short answer is poppycock, which is, if you look it up, that's one of those words that people over the age of 70 use. The framers spent so much time trying to figure out what the right assignment of powers was. And they were particularly worried about one power. They were particularly worried about the legislative power. This was the power that when you look at the Constitution, it occupies most of the space. If any of you have seen the Constitution as a document, not as one of those things we get from the Federalist Society and we page through looking for the most interesting thing in there, but as the actual document itself, what is most striking is how much of that document is devoted to the legislative power. Article 1 is the lion's share, well, not really the lion's share, which is everything, but what we would normally refer to as a lion's share of the document. It is the only power, the exercise of which, not just who gets to exercise it, but how it gets exercised, is spelled out there. And it is spelled out in great detail. You have to have people from both houses of Congress elected differently for different constituencies for different periods of time. You have to have presentment to the president, someone else who was elected from a different constituency for a different term. You have to have all of these agreed, or you have to have supermajorities override a presidential veto. These are very, very carefully designed structures to limit the likelihood of law being rushed through, to limit the likelihood of power being exercised in ways that are intemperate. We're used to politicians who make intemperate remarks, but intemperate lawmaking was something the Constitution was designed to prevent. That means that not only is the lawmaking power assigned to Congress, it can't reassign it. And those who were reading Locke and Montesquieu at the time of the framing know that was one of the things they expressly wrote about, that the legislature was to make laws, not to make lawmakers. The problem that we've had is not the recognition of that principle, but the application of it. So if you look over time, we start with the first important case on this, the first really important case, Chief Justice Marshall in 1825, when I was just a boy, writing in Wayman against Souther, when he said that Congress can assign power that isn't strictly legislative to others. But the legislative power, the power that has to be exercised by Congress, is the power to make important rules for the governance of society. This was Chief Justice Marshall ably stealing the words of Alexander Hamilton from Federalist 78. After that, the question was, what was an important matter? What was an important decision? We didn't put that to the test very often because the Congresses for the first 150 years or so didn't really give out much in the way of big powers by law. In Field against Clark, which is a tariff case, we tend to get cases involving transportation and cases involving tariffs for most of our really important non-delegation cases. In Field against Clark, there was a reduction in tariffs for certain items and an instruction to the president that if another country raised tariffs in a way that wasn't really playing fair after we reduced tariffs on these items, he could raise the tariffs back on those items. And everything that was needed doing was really specified there. Field against Clark says we recognize, it's universally recognized you can't delegate legislative power. In J.W. Hampton against the United States, which comes along in 1928, the decision written by former Chief Executive William Howard Taft says, of course you can delegate not legislative power, but the power to make important decisions, and the more important it is, the more you ought to delegate it to the president. But you need an intelligible principle. The intelligible principle test survived about 7 years and was applied twice in 1935, and then for all intents and purposes became a boogeyman that was trotted out periodically to scare people, but never was actually used again. In 1943, in the NBC case, the Federal Communications Commission, formerly the Federal Radio Commission, had the power to issue broadcast licenses as the public interest, necessity, and convenience dictate. And it decided in the 1940s it was also going to regulate the relationships between broadcast companies and networks and regulate what the networks did as well as what the broadcast companies did. The Supreme Court, in an opinion by Justice Frankfurter, said the structure of the act gave meaning to the phrase public interest, necessity, and convenience. And when he said that, he took it out of the part of the act where it actually had some discrete meaning, because he applied it not to the assignment of licenses or the allocation of broadcast stations, but to the pervasive regulation of broadcasting. So he made it clear that the intelligible principle test no longer actually had any bite. Later on, in the 1980s, Justice Rehnquist and Chief Justice Berger tried to resuscitate the non-delegation doctrine as a doctrine. They were unsuccessful in persuading anyone else to go along. By the 1990s and early 2000s, it looked like the doctrine was dead. I think Gary Lawson at one point toted up the wins and losses for the non-delegation doctrine, and in a relatively short period, I think he came up with like 53-0 against the doctrine actually having any purchase. By the time you get to the Whitman case, Whitman against the American Trucking Association, you have two justices saying, let's just forget about trying to have a non-delegation doctrine and admit it doesn't exist. And you have another justice, Justice Scalia, who says, we really have to be careful who exercises what power, but trying to find a way to actually have a workable non-delegation doctrine that doesn't just give judges a lot of power is tough to do. In the 2015, you have Department of Transportation against the American Railroad Associations. Justices Alito and Thomas say, look, we really need to take this seriously. There has to be some limit on what Congress can give to others to do, and the intelligible principle test ain't it. It simply isn't working. It's not constraining at all. We need to really revisit this issue. That case didn't provide a good vehicle because the issue there was whether they had a government entity or a non-government entity that was involved in regulation. We come now to this past term, Gundy against United States. You have 3 justices who argue for a real resuscitation of the non-delegation doctrine and a return to a version of it that looks like Chief Justice Marshall's. You have one other justice who says this is not the right case to take this issue on for reasons that have to do with the particular structure of the law and argument over the law's meaning. But I am available to actually participate in that task when it comes back in an appropriate case. And you had one justice who is a recent addition to the court, Justice Kavanaugh, who was not on the panel at the time the case was briefed and argued. So although he was there when it was decided, he was not participating. So is there now hope that we will have a working non-delegation doctrine? I'm with the rabbi on this. I think it's still moving, but that's what we're going to be discussing for the rest of the program. Thank you.
Okay, so I'm going to beg your forgiveness at the outset. As I've dutifully written up my notes, thought about the topic, written down what I thought, and then as I was reading through it earlier today, I was like, wow, what a Debbie Downer. And I hate to be that way. I'm a sunny, optimistic kind of person, and I was thinking, last year I was on this panel talking about finality doctrine, and it was like, hey, things are moving. And then I look at this, and it's like, oh, boy. Okay, so let me start by saying, you can put me in the camp of those who are disturbed at the extent to which Congress has been willing to abdicate its legislative authority and allow the executive branch to fill the void. I agree with Justice Gorsuch that even when a statute contains a high degree of overall specificity, delegating authority to an agency to adopt regulations based on open-ended terms like feasible or reasonable or in the public interest is at the very least troubling, if not a violation of the Article I vesting clause. At the same time, at a certain level, and maybe I am just getting tired and cynical in my old age, I have to wonder whether this is a case of here we go again. With Gundy, yet again, the Supreme Court has upheld a statute against a non-delegation challenge. And yet again, for those who wish that the court would apply the non-delegation doctrine with more or really any rigor, and that Congress would do its job of legislating rather than relying on agencies to do the hard work and make the hard choices, Justice Gorsuch's dissenting opinion in Gundy seems to offer some small amount of hope. Well, I'm sorry, but with all the hoopla notwithstanding, color me a little bit skeptical that the court is really going to do anything to give the non-delegation doctrine actual heft. Because we've been here before, right? 40 years ago, I was in preschool. Carl McGowan, John Hart Ely, Ernest Gellhorn made the case for reinvigorating the non-delegation doctrine and curtailing agency discretionary power. In the benzene case in 1980, the Supreme Court considered whether the Occupational Safety and Health Act, a statute that Cass Sunstein has said if any statute violates the non-delegation doctrine, it would be this one. The Supreme Court considered whether that act violated the non-delegation doctrine by allowing OSHA to adopt limitations for workplace exposure to harmful chemicals using an open-ended feasibility standard that itself was inferred from rather than explicitly provided by a statutory requirement that such limitations be reasonably necessary and appropriate. The court found the statute constitutional based on an interpretive inference that the statute required a finding of significant risk, though it also invalidated OSHA's regulation for failing to provide that finding. Justice Rehnquist concurred in the judgment, but citing Ely, argued that the statute was limitless and violated the non-delegation doctrine, giving us hope, right? Then 20 years ago, the D.C. Circuit surprised many people by declaring the American trucking case that the EPA violated the Clean Air Act by construing too broadly the Act's authorization of national ambient air quality standards, limited solely by fuzzy terms like requisite to protect the public health with an adequate margin of safety. The Supreme Court reversed, with Justice Scalia for the majority, rejecting the notion that an agency can cure an unconstitutionally standardless delegation of power, and also finding the statute well within the outer limits of the court's non-delegation precedents, and suggesting that the court would only rarely be qualified to second-guess Congress's decision to give agencies policy-making discretion. Justice Thomas concurred, but expressed willingness to consider whether the court's delegation jurisprudence had strayed too far from our founders' understanding of separation of powers. So, they knocked us down and then they give us hope, right? And now there's this case. Philip Hamburger's critique of the contemporary administrative state, is administrative law unlawful, has captured the imagination of many scholars and commentators. Hamburger rejected as unconstitutional virtually any statutory grant of agency rulemaking authority to adopt legally binding regulations, irrespective of whether the statute contains intelligible principles. Meanwhile, we have several justices on the Supreme Court on record expressing dissatisfaction with and a willingness to consider various aspects of administrative law doctrine to curtail agency discretion. So the court's taking up of Gundy prompted many to wonder whether this time, just maybe, the court would breathe new life into the non-delegation doctrine. And the saga's not over, because the court has not yet denied the petition for rehearing in Gundy. Still, and again, color me a little skeptical. Forgot one bit of my notes. So, Gundy concerns the constitutionality of a provision of the Sex Offender Registration and Notification Act, or SORNA, which authorizes the Attorney General to determine the applicability of SORNA's registration requirements for sex offenders convicted prior to SORNA's enactment. The provision, taken on its own, is quite open-ended. It directs the Attorney General to specify the applicability of SORNA's requirements and prescribe rules for the registration of pre-act sex offenders without further direction. Of course, that provision is part of a much larger statute that is reasonably detailed regarding the mechanics of registration for sex offenders, more explicitly covered by the statute's terms. Suffice it to say, the Attorney General relied on this delegation of authority to adopt regulations that required pre-act offenders to register, tweaking as necessary in order to fit within the details otherwise provided by the statute. Justice Kagan wrote the opinion for the court, representing a plurality of 4, and she read the statute as requiring the Attorney General to apply SORNA's regulation requirements as soon as feasible to offenders convicted before the statute's enactment. Of course, the relevant statutory provision doesn't actually include the word feasible, shades of benzene. Instead, Justice Kagan inferred this feasibility from SORNA's statutory declaration of purpose and legislative history, as well as the court's 2012 decision in Reynolds versus United States, which she said held that Congress clearly intended SORNA's registration requirements to apply to pre-act offenders, albeit only after the Attorney General adopted regulations. So in other words, SORNA obligated the Attorney General to adopt regulations adapting and applying the rest of SORNA's details to pre-act offenders with only a little latitude for feasibility. So, as we all know, Justice Alito concurred in the judgment purely because of stare decisis. A majority of the participating justices were unwilling to reconsider the intelligible principle standard when you had an 8-justice court. And given the court's history of applying that doctrine, he said it would be freakish to single out SORNA for special treatment. Justice Gorsuch writes his blistering dissent. Chief Justice Roberts and Justice Thomas join him. They describe the relevant statutory provision as permitting unbounded policy choices with profound consequences. In any event, so going from there, you might think, you've got 4 justices on record saying, hey, we're willing to reconsider the intelligible principle standard. Justice Alito saying, I'll reconsider it. Gorsuch, Roberts, and Thomas, thank you. Senior moment, long day. In any event, saying, we're ready. We've got an idea. We're going to get rid of it. And now all we need is Justice Kavanaugh, right? So you put all of that together. If we take everything at face value, it seems like we are tantalizingly close to getting rid of the intelligible principle standard and reinvigorating the non-delegation doctrine. The problem is, what then? Because it's notable that Justice Gorsuch, in his opinion, did not go the full hamburger, meaning that he did not reject delegation of rulemaking power altogether. Instead, he clearly contemplated that Congress is going to be able to continue to give agencies the power to adopt legally binding regulations. In fact, no justice seems willing to deny Congress the ability to delegate rulemaking power altogether. And Justice Gorsuch even seemed to find acceptable statutes that allow federal agencies to resolve even highly consequential details, so long as Congress prescribes the rule governing final conduct. Justice Gorsuch's primary objection seems to be with mushy terms like reasonable or feasible, and perhaps even then, not all the time. Consequently, any more rigorous replacement for the Intelligible Principle standards needs to facilitate some line drawing. You know, what actually is going to get included and what's not. Finding a better, more rigorous standard for discerning between acceptable and unacceptable grants of rulemaking authority is really, really hard, it turns out. Justice Gorsuch really tried. He outlined what he described as 3 important guiding principles provided by the framers. First, although Congress must make the policy decisions when regulating private conduct, it may authorize another branch to fill up the details. Second, although Congress must prescribe the rule governing private conduct, it may make the application of that rule depend on executive fact-finding. And finally, Congress may assign the executive and judicial branches certain non-legislative responsibilities. Now, all of that sounds really good until you start thinking about how to distinguish mere details from the policy decisions that regulate private conduct. Sometimes the devil of a statute is in the details. Applying statutes to individual facts and circumstances entails some amount of interpretation, and those interpretations can be policy-driven and highly consequential. Contrasting mere details with policy decisions and rules governing final conduct simply seems too susceptible to the same whim of the moment and too likely to go down the road of the Intelligible Principle standard. So, I want to say a word, too, about stare decisis. Justice Kagan's assertion that if SORNA's delegation is unconstitutional, then most of government is unconstitutional is clearly overblown. Yet, clearly, too, any more rigorous non-delegation standard that the court might adopt would immediately call into question the validity of more than a few existing statutes, some quite long-standing, as well as regulations implementing those statutes, and an even larger number of enforcement actions based on those regulations. Opinions in other cases in the last term suggested that some number of the justices are willing to approach stare decisis more aggressively and overturn past precedents. But the justices collectively have not really yet pulled this trigger, at least not in this context. So, this is not to say that those justices who think administrative law has tilted too far in agencies' favor should do nothing to rein in delegations they find objectionable. Justice Gorsuch went on to note in his dissent that the court still regularly reins in Congress's efforts to delegate legislative power just using different names, like the major questions doctrine or void for vagueness. And the court utilizes other doctrines beyond those to limit agency discretion. Just last term, for example, without overturning it, the court curtailed our deference in Kaiser versus Wilkie a little further than it had before. We're starting to see incremental movement in the finality doctrine that suggests that more sub-regulatory guidance actions may be subject to some amount of judicial scrutiny. Great. As statements about separation of powers and the roles and responsibilities of the 3 traditional branches, all of these different alternatives, void for vagueness and major questions doctrine and finality doctrine, et cetera, these alternatives lack the symbolic value and the heft and the punch at a certain level of replacing the intelligible principle standard. But they also lack the baggage. And there's some value in that kind of incrementalism or that kind of approach that maybe isn't so splashy, but maybe gets us where we need to go.
Well, I agree with Professor Hickman that the Gorsuch dissent in Gundy does not successfully draw the line. But I have some good news. I think there's a way of doing it, not to fully enforce the doctrine, but to enforce it somewhat. On the other hand, I have some bad news. I'm intending to use a little bit of PowerPoint. There it is. Okay, so here I go. The Declaration of Independence promised a government based upon the consent of the people. And to deliver such consent, the Constitution vested key powers in a legislative process composed of officials whose continuance in office would depend upon the consent of the governed. And it would undercut this consent of the governed for Congress to divest itself of legislative powers. And although paying lip service in just about every case to this principle, the court has allowed Congress also quite consistently to pass the buck, okay? So why the court has done so, I think, could be made clear in by reference to a book published by Professor Lawrence Lessig. He shows that the court, from the very beginning of the constitutional process down to today, both on the left and the right, has read the Constitution with reference to two considerations. One, they're supposed to come up here. There it goes. Fidelity to meaning. In other words, the original meaning. What does the Constitution mean? And also, secondly, constraints on the full judicial enforcement of this meaning needed to preserve the authority of the court as a judicial institution. Okay? Such constraints can prompt justices to adopt tests that under-enforce the Constitution's meaning. Okay. For example, the court says that the Constitution means that one person, one vote is how districts should be, should be assigned. Legislative districts should be assigned. But because of a variety of constraints, the courts actually allow legislative districts to differ in population by up to 10%. Right? So that test within 10% is different than the meaning of the Constitution. And there's no end of areas where the meaning and the test are somewhat different. Now, Lessig does not discuss the constraints on judicial enforcement of the delegation doctrine that lead to a test that's less than the meaning of the doctrine, but I will. Okay? The first such constraint is impossibility. It's impossible for Congress to make all the rules of public conduct. And that was recognized as early as 1825 in the Wayman case that Ron talked about. And obviously things have gotten much worse since then because we live in a much more complicated world that needs a lot more rules. Ultimately, this sense that Congress could not make each and every one of the rules of private conduct led to the form of the Intelligible Principle test that we started to have in the 1930s, which ultimately meant something like this. Congress could leave it to the agencies to make the laws so long as it said enough about the goals of the laws. But the problem with that, though, is it's a totally judicially unmanageable test because what's enough? How do you compare a statute in one area like employment discrimination versus another in, I don't know, constraint of trade? I mean, there's just no way of managing this thing. So that's the second constraint that has kept the court from doing much of anything. A third constraint is strong political hostility to the enforcement of the meaning of the Constitution. And that certainly came up during the New Deal when the court struck down in two different cases, the Panama refining case and the Schechter case, parts of the National Industrial Recovery Act. Now, and that turned out to be convenient for the court because, excuse me, it's the other way around. The intelligible principle test was convenient for the court because it allowed it to bow out of these very politically touchy issues. So that was fine from the court's point of view. But Lessig points out that since strong opposition is, in his words, quote, a force majeure, then it follows that when the force is removed, the obligation to return to the Constitution's meaning returns as well. And I think public opinion has turned against all this buck passing. In fact, there was a poll taken in January of this year where 80% of the respondents said that Congress should vote on the major regulations. And the 80% was consistent among Democrats and Republicans, and even a higher percentage among independents. And that's just one of several polls that I think point in that kind of direction. The fourth constraint that we now face with non-delegation is by the court allowing delegation for so many decades upon decades, Congress has built this edifice, this Code of Federal Regulations, which is massive, okay? And so if the court then knocks the whole thing down, what does one do? And if the court adopts a test like in Gundy, like in Gorsuch's thing in Gundy, the head of every organization, be it a government, a business, a union, a university, I don't care what, they're going to wake up in the next morning and say to themselves, what part of the CFR do I have to obey and what part don't I have to obey? It'd be absolute pandemonium, right? So we got a problem there. And by the way, I think the pandemonium would then reawaken the strong political hostility problem. So Gundy is not the way forward, the Gundy dissent. So here's how the court could, in fact, move forward to partially, substantially enforce the doctrine, but not 100%. So I'm going to go through these various constraints and talk about how the court could arrange to maneuver through them. Okay. Impossibility. Congress could take a lot more responsibility than it now does. We all know that. Okay? And a simple way of understanding that is to think about the suggestion made by James Landis, the guru of administrative law in the New Deal and then later dean of Harvard Law School. He proposed in a book published by Yale Press in 1938 that Congress would vote on the significant rules. Now, if significant rules were defined the way that the executive order that's been enforced for four presidential administrations, 2 Democrat, 2 Republican, there'd be about as many votes on those rules per session as votes on the naming of post offices. Now, a difference between the two is naming post offices is not a legislative power, but enacting the laws is. Okay? And following up on that, a judge by the name of Stephen Breyer published an article in the Georgetown Law Review in 1984 showing how the Landis idea could in fact work in a practical way through a fast-track process. It could be done. Okay? So that means that it's possible the first constraint can be overcome. Okay? There we go. Okay. So the problem, though, is that Congress doesn't want to take responsibility. And that isn't just the Democrats who don't want to take responsibility. The Republicans are just as bad. Take the REINS Act. The REINS Act actually incorporates Landis and Breyer's idea, but it's structured in a way, and I think intentionally so, that it could never pass. There's lots of poison pills in there that are not pro-responsibility, they're anti-regulation. The Democrats will never swallow it, it'll never get passed. Therefore, the Republicans can say, I want to be responsible, I'm for cutting regulatory costs, but they don't want to have to vote on the hard choices. So the problem is how we could actually get Congress to do the thing. Okay. So this is how I think it could be done. The court could dump the intelligible principle test, but instead of his test forewarn Congress that it will by a date certain strike significant new regulations whose promulgation by the agency Congress has not voted to approve. And there's some precedent for this. I mean, in Wayman versus Southard, the 1825 case, the court talks about minor regulations. That's all right to leave to the executive, okay? By the way, that part of the opinion is not mentioned by Justice Gorsuch. I wish it had been, okay? Now, of course, how you go about it and how you define significant regulations, there's some policy implications there. But the court has a way of finessing that one. Think about how they handle legislative redistricting after it finds that a current districting is not in accord with one person, one vote. They say to the state legislature, you district it. And by the way, if you don't do it by a certain time, we're going to do it, which means at that point, the court will have to make some very important, very political decisions. So Congress gives the court gives Congress the opportunity to decide how to do it, and if they don't, the court steps in. Okay? And I think the possibility of the court doing that might actually be a real shove towards the Congress actually doing it, partly also because the polls are pushing Congress that way. The public wants a responsible Congress. Okay? So, so what about the other parts of it? So when the court actually steps in, how does it come up with a judicially manageable test? Well, it could take the executive order, which, as I said before, has been enforced under Democratic and Republican administrations, take the first part of it, annual impact on the economy of $100 million per year, positive or negative, okay? And that would be the test. Now, there's other parts of the executive order that are much more amorphous, and Susan knows that better than me. But the court ought to leave those other parts out because they are amorphous and therefore not judicially manageable. But Congress could build them in if it took the responsibility. So the court would not be for considering other things like environmental impact or something like that. But Congress could add that in. Okay. Okay. So then I think $100 million, that sounds pretty judicially manageable to me. So that's number two. What about strong political opposition? Well, I've just said the polls indicate there's strong public support for a Congress that takes responsibility. I think that the ducking is part of why the polls show the public has such a contempt for Congress. So I think the political opposition, the strong political hostility, won't be a problem if we could deal with the fourth problem, which is reliance on delegation. Okay? So I'm on to that one. The court could point out to Congress that it could take care of all these old regulations by approving them en masse. Now, that's no real political accountability, but that gets rid of the problem for the time being. Okay? And if Congress is unwilling to do that, the court could, I believe there's a very strong argument for this, despite some cases we could talk about later, could make the new standard applicable only to new regulations, not existing regulations. So we knocked down all four of those constraints. Now, there's a lot of issues to be parsed out here, and I don't have time to deal with them all here, but there's an article that's going to be published soon in the Harvard Journal of Law and Public Policy I've written that marches through them. It'll be out in January. I hope you're patient enough until then. But I think there's one point I do want to say a little bit about. Is this too bold for the court to do? I mean, it would be quite a change, right? Well, I have a couple of things to say in defense of it. Number one, it's sticking with the original meaning. And in fact, the meaning that the Supreme Court has given lip service to consistently from the beginning. Okay? Number two, it would be a new test to better deal with constraints on enforcement. And the whole point of Lessig's book is, not the whole point, but a big point is that when there's better ways when the court realizes there's better ways of getting around constraints, or times have changed and the constraint isn't there anymore, the court has done it. It has changed its tests. And in fact, one change it made was adopting the Intelligible Principle test. It's done it with delegation. Okay? Okay, so in closing, I want to say this. Instead of enforcing this doctrine, this fundamental doctrine that has to do with, I think, the most important principle in the Constitution, which is principle about consent of the governed, and so in response to that principle, in response to the argument that Congress unconstitutionally outsources its responsibility for the laws, the court outsources to Congress its responsibility to judge compliance with the Constitution. That is poetic injustice.
So, happy to be here, and I, as a famous orator once said, I do not come to praise delegation nor to bury it, but rather to see that it's properly applied. The proof of the validity of a theory is, in my judgment, dependent upon how it's applied in practice. So I want to talk to you about a case in which I'm the chief counsel that's litigating the delegation doctrine this very time. The case is called the American Institute for International Steel against the United States, and it involves the delegation that Congress gave in the Trade Expansion Act of 1962 to the President of the United States to control the level of imports of products into the United States. The case is now in the Federal Circuit. It's going to be argued the first week in January. And the question is a question presented about a prior case that the Supreme Court handled on this very question. But ultimately, if the case gets to the Supreme Court, that prior decision will not be of any impediment to the court if it wants to be impediment. Doesn't want to be impediment. If it wants to be impediment, it can duck it that way. But the question presented is the national security delegation in Section 232 excessive under the delegation doctrine? First, let me start with a couple of facts about the statute and how it's operated in the context of the delegation that the President used in March of 2018 to impose tariffs on all imported steel. The President chose to impose a tariff of 25% on all imported steel. That number is completely made up. It's not contained any place in the statute. He could have imposed a 5% tariff or a 50% tariff. He could have imposed quotas, licensing fees, import restrictions. Anything he wanted to do, he could do under the statute. And by the way, nobody disputes that. In fact, 6 months after he got into the statute, he got angry at Turkey, and so he doubled the tariffs on the steel imports from Turkey to 50%, and then 6 months later, he backed down and said, no, I'll back them off. While this was going on, he initially imposed tariffs on everybody, and then he changed his mind and said, we'll have quotas for some, and we'll have other restrictions for other people. The people that I'm happy with will get one, and the other people we're happy with other trade agreements will get another, all entirely within the limits, without any limitation in the statute whatsoever. I gave a talk about this statute to a bunch of trade lawyers 6 months ago, and I said to them, all steel products are not fungible. And the room broke out laughing. And I said, I never realized that was such a funny statement. Well, it is to trade lawyers, because it turns out that there are 177 different classifications of steel under the import tariffs, and they, in fact, are not fungible. They're used for different purposes. They come in different ways into the United States. Some of the steel products are finished products or semi-finished products. They have very different uses in the industry. The standards are very different for all of them. And in some, we have no defense needs for them, and some we have major defense needs for them, and some we have more than adequate supplies in the United States, and others we do not have. But the President chose, because he could do so, to treat every steel product exactly the same. Third, he gave no consideration to the adverse effects on other segments of the economy. For those of you who are aware of what happened, not unexpectedly, foreign countries retaliated massively against the United States. And guess who was the biggest loser in these? The farmers. And so, for political reasons, the president has now spent $29 billion on farmers to subsidize their losses of crop sales overseas, and there's more coming down the road, and that's all because he didn't have to take into account these other facts, even though everybody who was aware of the industry knew what was going to happen. Finally, there's no judicial review whatsoever of the president's determinations of any kind. Everybody agrees with that. Even the Justice Department agrees that there's no judicial review. And that's because the decisions are those of the president, and he is not subject to the Administrative Procedure Act. In addition, there are no notice and comment provisions. The president's decision on 25% was never subject to any question as to whether it's the right number or anything else. And so we have essentially a president who can do whatever he wants to do because he can do it. So what's the legal theory of the case? The legal theory is actually quite simple. It may be wrong, but it's quite simple. We looked at the statutes that Congress has passed and that the Supreme Court has upheld. And in every one, the court talks about boundaries. There have been boundaries this way and that way. And we say in this situation, there are no boundaries in Section 232. We have been challenging the government since the case began. Tell us one thing that the president cannot do under this statute other than affect products that are not imports. That is, he can't deal with domestic products. And the government has been unable to challenge at all, has been unable to respond at all. And so we say the president can do anything he wants to do. And we cite, reminiscent of this, the case called United States against Lopez, which is, most of you know, a Commerce Clause case, in which the court said to the government, tell us what the government can't do, Congress can't do under your theory of the Commerce Clause. Solicitor General was unable to explain what Congress could not do, and the court said that shows that there are no boundaries under the Commerce Clause. We have a system of limited government that cannot be the right answer. And we cite Lopez, and we think the same principle applies to Lopez as applies in this case here. All right. Now, in terms of the analysis under the statute, we break statutes down into two parts. This is not something that other cases have done, but I think it's consistent with what the outcome of the way courts have actually analyzed them. The first part, we examine what is the trigger. That is, what must the agency, or in this case the president, find in order to be able to employ the remedies under the statute. So the trigger here is that the level of imports and the circumstance of the importation may have an adverse effect upon national security. Well, you say national security, that could be very broad, and that the president's got a lot of authority under national security. Well, not quite so fast. Two things about that. First, in this very case, as required by statute, the Secretary of Defense was asked, what about the national security implications of imports of steel? Secretary of Defense wrote a letter, which is in the record, says, not a problem. We got all the steel we need for all the defense needs. National security by the board. Second, and this is probably the most significant, the statute doesn't stop with national security as most of us think of national security, but it includes in a very long paragraph, which you cannot say in fewer than 5 or 6 breaths, that it includes essentially everything in the economy or any industry in the economy. In other words, anything. And so we say that the trigger on the front end is as broad as it could possibly be for imports. In other words, they don't have to find anything, and of course there's no judicial review. In that connection, this case was filed in the Court of International Trade, not my usual venue for litigation, but that's where it had to be filed. And when we had the hearing there, the judge said to the counsel for the government, could the president ban the importation of peanut butter? And the government lawyer hemmed and hawed and didn't answer the question at all. But the one answer she had for the question was, well, whatever he did, the court could not review that determination. Translated to me means, yes, the president could ban peanut butter under this importation of peanut butter under this statute. So we say that the trigger is very broad, but our principal focus is on the remedies. That is, the president has, as I outlined before, an unlimited choice of remedies. There's nothing he can't do in any amount, for any reason or for no reason, just because he's the president and there's no way to control it either in the statute or otherwise. He can do whatever he, in the language of statute, deems appropriate. And if that isn't open-ended language without a boundary, I don't know what it is. So, what does Gundy have to say about all of this? I looked it up today, and Gundy's cert was granted in Gundy 10 days before the president issued these tariffs. I knew about the cert grant in Gundy when I saw about the tariffs being issued. I talked to one of my colleagues who's a trade person and said, what's this statute all about? He pointed me to it, and I said, Gundy says maybe there's some life in the delegation doctrine, and so let's take a look at it. And we looked at it and found, yes, that there's at least some interest in the court in reviving it. When Gundy was granted, there had been 11 circuits that had looked at this question, and every one of them had come down in favor of the government. And the cert had been denied half a dozen or 15 times before Gundy came along, and the cert was granted. Something was going on there which gave us some hope. So in that sense, Gundy surely, for those who are concerned about the extent of delegation, gives us some hope. What does Gundy actually decide? Not very much. If you read the opinions, or when you read the opinions, Justice Gorsuch's principal debate with Justice Kagan, it was over what the statute meant. Justice Kagan saved the statute by claiming that it dealt with feasibility. That's a very difficult argument to make. The government had not made it in the prior cases under the statute, and she made the argument, and she got 3 other votes to go along with her. Justice Gorsuch said, well, that's not feasible, that's not a proper interpretation of the statute, and since it's completely open-ended, then therefore it's unconstitutional. Justice Kagan said, well, if you interpret the statute the way I do, there's no delegation problem at all, and I think that's probably correct. If the word's feasible, if the word said, Attorney General, you should do this as soon and as comprehensively as feasible, I don't think anyone would have thought that's a very good delegation case to take, no matter what your views are on the doctrine. But that's not what the statute said. Second, Justice Gorsuch spent a lot of time doing what in some respects sounded more like a treatise or a law review article rather than the application to a particular set of circumstances. And so I don't take much from the decision other than the fact that there is obvious interest in the court in cutting into it. As Kristin said a moment ago, Gundy rehearing has been filed. The basis for the rehearing is that there were only 4 justices. There are now, only 8 justices. There are now 9, and so we should have a decision reviewed, reheard. But in addition, there are 2 other cert petitions, at least, with the exact same question presented, that they don't have to have rehearing. It's on the conference again for tomorrow. This is the 8th time this case has been on the conference. Just as we wondered about what was happening with Gundy the first time it got decided, we're wondering what's happening and what's taking so long this time as well. All right. So let me just, in addition to the open-endedness of the trigger and especially the remedies, we point to a couple of other factors. The absence of any judicial review of the discretionary determinations by the president. If, as the court has said, we have to be able to determine whether the agency or the president is following the law. If there's no judicial review, that's impossible to determine by Congress, by the courts, or by the people, whether the president is obeying the law. And the absence of judicial review is, in our view, a recognition by the Congress that there is nothing to review, that they intended to give everything to the president, which is exactly the delegation problem we're talking about. The APA doesn't apply in any of its procedural requirements. None of the other executive protections are there. So let me turn last to a somewhat broader notion about delegation. I think the fundamental reason why delegations have been approved is the recognition that while Congress can make a number of important policy determinations, it cannot do what the voting members of Congress and the public want the government, the federal government, to do today. Just think about the Whitman against the American Trucking Association case. There's no way that Congress could have written those rules if it wanted the rules written and required that be updated every 5 years. It can't pass the budget. It can't do other things that are essential. How in the world is it ever going to do anything like that? Now, maybe people think that's okay. We don't need those rules, shouldn't have them. But as long as we're going to have the rules, we've got to have some system under which Congress can delegate substantial authority with, in that case, full APA review of the determinations made by the EPA there. Second, and this is really what Gundy was all about, Congress was unwilling to make hard choices in Gundy. One House of Congress said that these provisions for notification should be retroactive and should apply to offenses that occurred before the date of the statute. The other House said, no, they shouldn't be retroactive, and the states actually supported that because they saw this as an additional burden. So there was an important political question to be decided. So when they went to conference, they decided to split it down the middle and by giving it to the Attorney General. That seems to me to be fundamentally wrong, having nothing to do with the lack of expertise in Congress or the inability to predict the future or time or anything like that. They just refused to make a clearly difficult political decision, and it's hard to understand why we have to protect that kind of non-decisional activity under the delegation clause or otherwise. Two other points I want to make about this. One is that laws like Section 232 were written at a time when we expected those carrying them out to abide by some norms. The statute has been used dozens or so times since it was enacted, almost always in the case of petroleum, for very short periods of time, modest levels of control by the government. And now this steel imports is, at least according to all the trade lawyers I've talked to, like no other act under Section 232. Far broader, far longer, much bigger ramifications than ever before. And it's the breaking of the norm, which is permissible only because the statute has no norms or controls in it, that is problematic. And the Congress has to try to recognize that when they write the statutes and see how broadly they might be construed, not how broadly we think they will be construed as we go forward. Congress clearly can't do everything, but it surely should be able to do more than it's doing now. My goal is not to try to stop the administrative state, but to make it more accountable. Thank you.
I'd like to thank panelists for their comments, and maybe we could have some rebuttal time, and Ron or Kristin, if either of you would like to respond to David's proposal, that might be a good way to start it off.
Well, let me just make a few observations. First of all, David mentioned that 80% of the public believes that Congress should make all the important decisions. I'm skeptical about polls because I think 80% also believe that we should adopt only the first 5 words of the First Amendment, which says Congress shall make no law. While people want Congress to make hard choices, they want Congress to make the hard choices their way. And one of the things that Congress has learned is that you get further by making no hard choices than you do by making unpopular hard choices. Alan was talking about the peanut butter issue. I think that's a sticky issue. So I'll leave that. The problem, I don't think that I admire a lot of David's work in this area, and David's been writing things in this area for a very long time. I don't think the rule that he's proposing is one that the court really can do. I don't think the court can adopt essentially the same sort of rules that the OIRA operates under in terms of the amount that makes a rule a major policy rule that triggers OIRA review. I do think that all of us are grappling with a way of operationalizing the non-delegation norm. It is hard to do. I think that Chief Justice Marshall almost 200 years ago, time passes very quickly, when you're having fun with topics like this. I think he came as close as you can. I think just saying that you have to make the most important choices is about as good as you're going to get. And having the court periodically step in and strike something down for not making the hard choices. You were talking about having incremental progress. I think incremental progress is better than excremental progress. Doing crappy things is not as good as doing good things, even if you do them a little at a time.
Kristin, I don't know if you had anything to add, or maybe we just move on.
How could I follow that?
Yeah.
I think the only thing I want to say with respect to David's proposal is that one of the difficulties here when you start talking about getting Congress to make the hard choices is that the sheer volume of what agencies are doing at this point, I think to the extent we try to run, I mean, this has always been the problem with the REINS Act, right, is that when you contemplate Congress considering all the things that agencies are doing, there aren't enough hours in the day for them to tackle all of that. That doesn't necessarily, it's not a very satisfying answer. It doesn't necessarily mean that we should be happy with the status quo, so much as it does present just a logistical difficulty when you start talking about Congress making the hard choices.
And David, you feel free to kind of respond as you want.
There's some things they said that I'd like to respond to.
Okay, go ahead and do that, and then I have a question.
So Ron, I mean, you say that Congress gets nowhere by making the hard choices. Well, I agree in terms of re-election that this is not, making hard choices is not the way to get re-elected. But, if we have a situation where, they're stuck in a corner, then I think they're going to have to make the choices. And I don't think it's a question that, of one where, like you're saying, Alan Morrison is saying, well, Congress just doesn't have the expertise. I go back to Landis. This is what Landis said about this kind of thing. We have the administrative agency as the technical agent in the initiation of the rules of conduct, yet at the same time to have the legislative branch share in the responsibility for their adoption. I think we could have the best of both worlds. And now, and to me, either the Gundy-Gorsuch dissent or knocking off a statute every once in a while is not a good idea. I mean, Justice Scalia, when he was a law professor, wrote an article in Regulation magazine in 1980 saying, every once in a while the court should knock off a statute. Well, he got on the court, he didn't do it, right? And the reason, I think, fundamentally is that unless you could explain why you're knocking off this statute or that statute, it looks totally lawless. It looks like a judicially unmanageable test. It shows Congress, would show the court picking and choosing among statutes and regulations. And that's just terrible for the court. That really does look quite political, not judicial. So it seems to me that if they do something kind of analogous to one person, one vote, and they make a bright line, then they're not picking in like $100 million a year. They're not picking and choosing, and they're insulated to some considerable extent from the accusation that they're being political.
I can't resist. The notion that a court, the Supreme Court, should draw a $100 million line as a constitutional principle seems to me to be offensive to every notion that I've ever heard in judiciary. That's not, you can't have a reasoned explanation. Are they going to put an inflation adjustment in as well? And CPI with or without adjustment? I mean, just no. That's just not an answer to the problem. Nor is the answer to the problem words like important from Weymouth or technical or fact-finding. Those just are so squishy. We ought to recognize that let's take the EPA regs at issue in Whitman. There were significant policy choices made in those regulations. That's what the companies were unhappy about. They didn't like the choices that had been made. Some of them were made in the statute, but they cannot ever be a situation in which Congress is going to be able to fill in all the blanks. And as long as the Congress is going to pass laws that the American people seem to want, in these areas, we're going to have to accept some degree of delegation. My submission is there've got to be some outer limits. There've got to be some way in which we can say that the agency has gone beyond what they've been permitted to do. And the Congress has to pay more attention to the remedies and what is available and what the agency or the president can do. But writing $100 million in a constitutional decision offends my every sense of what judicial decision should be.
I'd like to reply very briefly to that.
Okay.
So, in defense of my position, first of all, I would have the court give the first crack to Congress to draw the line. And if Congress doesn't, then the court could say, like it does with the redistricting, that we gave them a chance, they didn't do it. And they could revert to the $100 million because that has some bipartisan authenticity to it. Yes, it is. The Constitution says nothing like $100 million, but it also says nothing about why 10% variation is good enough, is the right line to draw with one person, one vote.
That's only for the states. There's no variation in the federal Congress. That's only for the state rules on one of their houses. But anyway, we will disagree about this.
Okay.
Well, Ron, in your article, Delegation Reconsidered, you took the position that the non-delegation doctrine should focus first and foremost on the nature of the authority granted by Congress. In your view, do the rules announced in Gundy, does that do the work that you were looking for?
Well, I'm fundamentally sympathetic to the approach in Gundy, although I think that there is more attention paid to the scope of the delegation than simply to the nature of the delegation. But obviously, there's language in the opinion for Justice Gorsuch and the Chief Justice and Justice Thomas that does take up the importance of the nature of the regulation of rules for society. When you look at what we have now, we have a U.S. code of about 30,000 pages, and we have a code of federal regulation of agency-adopted rules that runs over 200,000 pages. And it's like reading a bad novel 200,000 times. A lot of that 200,000 pages are rules that are criminally enforceable. And if the notion of due process means anything, it means that you need to have the legislative authority adopt the rules that if you violate them, you're going to be guilty of a crime. In the old days, the criminal code either consisted of things that everybody knew were criminal. You know, you could write it on a few stone tablets. And for most people, you know, I think of it as the 10 Commandments. I think Bill Clinton called it the 2 Commandments and the 8 Suggestions. But I may have that wrong. Although I do think Moses came down from Mount Sinai and said, good news is I got him down to 10. Bad news, adultery is still in. You know, I think it's important that if you're not going to have rules that are intuitive to everybody, that everybody understands are criminally punishable, that they're adopted by the legislature and they're adopted in clear terms. I also just would say one thing on David's comment about we can have the best of both worlds. I'm reminded of the conversation Winston Churchill had with a lovely young woman who said, you know, Winston, we should get married, think of the children we'd have with your brains and my beauty. And Winston said, yes, ma'am, but think of the children we'd have with your brains and my beauty. It's not always easy to get the best of both worlds.
Alan, you talked about your case and that's going up now, or you have now before the Federal Circuit, and you are now dealing with Gundy, which I take it was not there when you were in the lower court. Now that Justice Gorsuch has weighed in, and he seems to approve delegations that implicate the president's inherent Article II authority over national security and trade, do you think you have to address or convince Justice Gorsuch, if your case were to go up to the Supreme Court, would you have to convince him to soften his views on that point?
to soften his views?
No,
Well-
no, I mean, he seems to agree with me, but I read his opinion as being far broader than what I need to have to win my case. We have not included a lot of discussion of Gundy in our Federal Circuit brief, largely because we tried to focus our case on this statute and how open-ended it is. And Gorsuch's opinion is more philosophical and broader, and it deals with a very different statute. And one of the points that we make throughout the brief is that each statute has to be looked at on its own, examining both the trigger and the remedies, and that therefore looking at what the court did in another statute is not all that helpful, particularly when the principal issue in that other, in Gundy, was what the meaning of the statute was to begin with, and we say that's not the problem in our case.
But I guess the question is, do you think that, a statute dealing with national security or trade would be the right statute to take up, kind of post-Gundy if it's not reconsidered?
Well, Gorsuch does talk about national security, and the government does raise the national security flag in defending the statute. But we think that that's not a fair designation of what the statute is about. And as far as this being the right case, this is a case we have clients with real money at stake, and they want to challenge this, and we think that if as one of the judges said in the lower court, if this isn't excessive delegation, please tell me what is. And kind of that's our theme in this case.
And we have time for questions if anyone has any there. Go ahead.
Devin Watkins from the Competitive Enterprise Institute. The primary problem, it seems, that you're describing of Justice Gorsuch's opinion is that it doesn't draw a bright enough line for you, that it's a little too squishy to be able to be properly judicially enforced. As someone who wrote an amicus brief in the case, and I see Justice Gorsuch's opinion as quite a bright line rule if it's properly understood, especially his part about J.W. Hampton. J.W. Hampton and the Intelligible Principle test, he seems to suggest, was rightly decided. It is the later courts that misinterpreted the Intelligible Principle test to allow things like in the public interest or whatever as being an intelligible principle that were not actually understood as an intelligible principle in that case. And especially if you look at Justice Story's commentaries on the law of agency, which was cited, and they quoted the Latin phrase from that treatise, where they get into the principles of agency and that the people delegate their power to Congress, and that then under the common law of agency cannot be subdelegated but for ministerial acts. That seems to be a very bright line rule between questions of fact and questions of law that seems to be at least justizable.
So I'm going to take this one, or I'll tackle it. I think there's a very big difference between contemporary statutes and the statutes of the era of J.W. Hampton. And I think therein lies a big part of the problem, because the test that Justice Gorsuch describes, I think, is easy when you have a simple statute. I think it's really, really, really hard when you have 1,000 pages of Affordable Care Act or, Sarbanes-Oxley or Dodd-Frank or whatever, where the difficulty really does lie in the fact that the policy issues are embedded in all of the arcane details. It's not just that Justice Gorsuch's test is mushy, it's that in the face of contemporary statutory text, I find it meaningless. And that's where, I haven't written the article yet where I try to apply it in some cases. I'm hoping to maybe do that in the spring, or some statutes, I'm hoping to maybe do that in the spring. But at the same time, that's the fundamental problem that I have, is it's not just that it's mushy, it's that it's meaningless in the face of the details and the complexity of contemporary statutes.
Yeah, I agree with Kristin that the problem with the opinion is it doesn't tell you which other cases are going to come out differently. He says there's been this big change after Hampton, but doesn't tell you which actual cases he would decide the other way, and more importantly, what aspects of those other statutes make them improper delegations.
I would pile on and say that the test doesn't make clear how much, doesn't make clear that whether Congress has to specify the rules or the goals, and if so, to what extent. It's kind of like I know it when I see it, and I think it's harder to know when you have more complex statutes. But beyond that, the very fact that we have all, these 200,000 pages of Code of Federal Regulation means that all of a sudden, overnight, the whole thing is somewhat under a cloud, and people aren't going to know what to do. And I think would create an atmosphere of crisis in terms of, for those people who are regulated, and also the people who are, with advocacy groups, be beating up frothing up the resentment, and it would just be a terrible pressure on the court.
Let's take another question here.
You've mentioned Obamacare. One thing that comes to mind is Chevron counts, except if it's really big, then we don't apply Chevron. It sounds like that same idea, whether it's 100 million or not. What you could say is if the delegation is really big, then we don't allow it. But how do they do that with Chevron? How is that somehow justiciable and some other bright line isn't? But my real question is, no one has mentioned the Congressional Review Act, I don't think. I think we've mentioned Reins. Does the Congressional Review Act have any effect on this analysis?
Well, what the Congressional Review Act does is it gives Congress the option whether to vote on hard choices, whereas the kind of statute I'd be hoping that Congress passes is one that would require them to vote on the bigger regulations. Now, in point of fact, up until Trump was elected, Congress only opted to make the hard choices once. And the reason that there was so many votes possible after Trump was elected was the Obama administration wanted to put all the hard choices off until the end of the term, hoping then, expecting that Hillary Clinton as president would make sure that nothing got bumped off. But even with the Republicans in charge of the Senate, the House, and the White House, they did not vote on most of the things that they could have voted on. They only voted on the stuff that were easy votes for their party in Congress.
Let's take a question over here.
Thank you. Brian Bishop from the Stephen Hopkins Center for Civil Rights. And I wanted to quickly throw David a bone in his argument about the court establishing arbitrary numerical filters for this. I do believe that there was a case that was effective in the federal arena that said something about a law going on for another 25 years. I think it was Sandra O'Connor said that. And It just seems to me that, as you pointed out, it's quite common for the court to resort to this. But I also wanted to add, I think the importance here that we haven't hit is emphasizing the distinction of the process or the protections that the constitutional structure provides versus the substance of rights. And an area I was hoping that we'd see a challenge is on the president's orders on immigration, operating under 8 U.S.C. 1182, where it says that whenever the president finds that the entry of any aliens of any class would be detrimental to the interest of the United States, he may, by proclamation, suspend the entry of all aliens of any class. Now, I mean, that has no, I mean, there is a word in there is detrimental. But this is an area of substance, it seems to me, that would attract suddenly much interest in whether or not that is a proper delegation.
Yeah, I don't know.
Well, okay, so I'll bite. I'll try. So one of the things that I think is really interesting here is that we are fixating a lot, and I understand why, on broad, highly subjective, quasi-meaningless words like detrimental, feasible, reasonable, et cetera. And I do think rightly so, because they're contentless, right? You can look them up in the dictionary, but that doesn't tell you what they mean in the context of a statute. I'm not sure that's the right way to fixate, because at least one, Maybe not with respect to that particular immigration context with which I am less familiar, okay? But at least in a lot of administrative law contexts, when you have an express delegation to do something, and by this I mean explicit, but rather than the implicit feasibility that Kagan read into the statute in Gundy. But, you always have State Farm as a backstop. Where the court, the agency at least has to articulate its justifications for acting the way it is, and you've got judicial review on that basis. There's not much to interpret as a court with words like feasible or reasonable or what have you. Actually, the delegations that bug me on a certain level are the ones where the statute just gives the agency the authority to adopt all needful rules and regulations to effectuate the statute without specifying exactly what beyond the four corners of the larger statute those rules might actually do, and then leaves it to the agency to fill in the blank as it finds it.
If I can jump in on this as well. There are terms like reasonable that we've had in different contexts, reasonable rates. We've had a whole body of what a reasonable rate consists of that was worked out at common law and then taken into statute laws. The problem is when you use those terms outside a context where it has a defined meaning or a relatively definite meaning or a body of law that gives it some structure, that's the place where you're in the soup. That's why I go back to the NBC case back in 1943, where you had, and when you're looking at assigning different frequencies, you have a series of problems involving where frequencies will interfere with each other. How much separation do you need? How wide an area can you allow a frequency to operate in, which is a function of the power as well as the nature of the broadcast? How wide an area can you have it operate in without creating a series of problems? And what you had being worked out by the Federal Radio Commission and then by the FCC was a series of rules about the technical aspects of radio allocation. What Frankfurter did in the NBC case is said we can apply that to the entire field of broadcasting and allow regulation of the entire field based on that. That is what gives the green light to Congress to enact statutes that give out large amounts of power without real defined understanding. And then whatever happens ex post, this is the question about the CRA, whatever happens ex post is largely a function of other political decisions. And Congress works hard at using its power over appointments to the agency, oversight of the agency, to do a different version of lawmaking, but it's one that doesn't in any way involve the sort of lawmaking process that the Constitution has. So I'm sympathetic to Justice Gorsuch and Justice Thomas and Chief Justice Roberts' effort at trying to find a way to cabin this, even if it is an imperfect effort.
All right, I think we have time for one more question here.
Thank you, Judge Cameron Atkinson from Connecticut. So Chadha kills even the prospect of a bicameral legislative veto. Scalia's dissent in Morrison would essentially preclude that as an option. So my question is when we look at the broader context of Congress starting to either delegate power to an administrative agency or work with an administrative agency, aren't the courts really falling over themselves in essence to create a non-delegation doctrine because they haven't taken the step of going back and reaching a more definitive conclusion on their interpretation of what the words in the necessary and proper clause actually mean?
I don't know who wants to take that one, David or Kristin. You can take another stab.
That's a tough one.
Good answer.
If we think it's hard for the court to back down of the delegation doctrine, I think the necessary and proper clause is even harder.
I'll second that one.
I third it.
Okay, I think we ended on an agreement, and I'd like to thank the panelists again for their time.